I'm going to call this meeting to order. Bienvenue à la réunion numéro.
Welcome to meeting number 108 of the House of Commons Standing Committee on Access to Information, Privacy and Ethics. Pursuant to Standing Order 108.3H and the motion adopted by the committee on Monday, October 30th, 2023, the committee is resuming its study of the decision of the Royal Canadian Mounted Police to not pursue a criminal investigation in relation to the SNC-Lavalin affair.
The meeting is taking place in a hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application. And again, a reminder to all that are participating to make sure that you keep the earpieces away from the microphones because they could cause potential injury to our interpreters. I'd now like to welcome our witness for today, Mr. Michael Warnick, former clerk of the Privy Council, currently Jarolowski Chair in Public Sector Management at the University of Ottawa. Before we begin, I am going to ask again for unanimous consent to reset the clock at the top of the hour to give the opportunity to our Bloc and NDP members a chance for 6-minute questioning. Do I have unanimous consent on that? Sure. Thank you. Now, I understand, Mr. Warnick, first of all, I want to welcome you to committee. I understand that you do not have an opening statement today, so I'm going to go to questions, and we are going to start with Mr. Barrett for 6 minutes. Mr. Barrett, go ahead.
Sir, has the RCMP contacted you regarding Justin Trudeau's role in the SNC-Lavalin scandal? His response was not audible.
Yeah. Mr. Warnick, sorry, you're going to have to hit unmute. There you go.
Oh, sorry. The usual Zoom mute, unmute. Sorry, I did hear the question, sir. No, they have not.
But you were interviewed for the Ethics Commissioner's report, the Trudeau 2 report on the SNC-Lavalin scandal. Is that correct?
Yes, I retired in April of 2019, Easter weekend. I was interviewed one time by the commissioner in the preparation of the report. I was interviewed by the RCMP that summer about the lobbying activities of principals of SNC-Lavalin.
And did you have any further contact with the RCMP following, with respect to SNC-Lavalin, following that interview in 2019?
Never prior and never after.
Did the RCMP ask you about, did they ask you any questions dealing with Justin Trudeau?
That was 5 years ago. I do not remember the flow of the interview. We basically went over the material, which you will see in the Commissioner's report.
You don't remember if the Prime Minister's name was said by the RCMP? I can tell you, I've as part of complaints that I filed with the RCMP, have been interviewed by them, and it was years ago. I remember very distinctly how that interview went, and I certainly would remember if the Prime Minister's name was mentioned. It was, I can tell you, in my case. Was the Prime Minister's name mentioned? Was a question asked of you about Prime Minister Justin Trudeau when you were questioned by the RCMP?
The interview took the form of going through the chronology of events, who met with whom, who spoke with whom, communicated with whom, and so on. And so, yes, the role of the Prime Minister came up because I was in contact with the Prime Minister during that period I was clerk.
The question of obstruction of justice, which is a criminal offense, was raised with respect to the Prime Minister's involvement in the SNC-Lavalin scandal. This is, of course, events in which you were involved. Most Canadians would have expected that you would have been interviewed on that subject. Do you think you should have been interviewed in the RCMP's pursuits with respect to obstruction of justice concerns or allegations about Prime Minister Justin Trudeau?
I have no view on that, Mr. Cooper. It's up to the police who they decide to interview.
Thank you very much. My esteemed colleague, Mr. Cooper, will have questions for you later. I'm Michael Barrett, and I did have the opportunity to ask you questions when you appeared at the Justice Committee about the SNC-Lavalin scandal, and I'm glad that we have you here today as well. Do you have any view on who the RCMP should have interviewed? We have a list of who the RCMP, or excuse me, who the Ethics Commissioner interviewed. We know who the RCMP interviewed, but those lists aren't the same. Justin Trudeau, Katie Telford, Jerry Butts. Do you think they should have been interviewed to exonerate the Prime Minister?
I have no view on who the police should choose to interview. Not every issue of ethics or behavior rises to the level of a preliminary investigation or fact-finding or examination. Not all of those move on to a full investigation in the terms that journalists and politicians use them. These are decisions to be made by the police and by the prosecutorial service.
We know that the Prime Minister broke the law. That's a matter of public record, him having broken the Conflict of Interest Act. There was a finding of that by the Ethics Commissioner. And we know that there's a big gap in the RCMP's work, and it's very curious about how that came to pass. If the RCMP were to pursue an investigation into the SNC-Lavalin scandal and Prime Minister Justin Trudeau, would you fully cooperate?
Of course.
Another law enforcement agency, the Ontario Provincial Police, for example, were to undertake an investigation into the SNC-Lavalin scandal, would you fully cooperate?
Of course.
Do you possess any documents related to the SNC-Lavalin scandal or the deferred prosecution agreement?
No, I left government in April 2019, 5 years ago.
Okay. And the question wasn't when you left government the second time that you've offered us that date. The question was about you having the documents.
I have no documents.
Why did Justin Trudeau go to such great lengths to pursue a deferred prosecution agreement for his friends at SNC-Lavalin?
I have nothing to add to my testimony at the Justice Committee 5 years ago.
You have nothing to add. So, there was no rationale. So, if I were to say that it was to help out a liberal-friendly firm, you have nothing to add to that?
I gave my testimony at 2 meetings of the Justice Committee 2 parliaments ago, and that's my account of events.
Well, the history is quite clear that there was not a case made, and we've of course heard the now famous recording of you and the then Attorney General Jody Wilson-Raybould when you claimed, without any evidence and without any substantiation, it's yet to be provided, that it was about jobs. And we know that it was never about jobs. It was, in fact, about politics.
Thank you. Thank you, Mr. Barrett. That concludes your 6-minute round. Ms. Damoff, 6 minutes, please go ahead.
Thank you, Chair. Mr. Wernick, thank you for being here today on something that I really question, given that you left government 5 years ago, what you can add to a police investigation, quite frankly. I wonder if you could, I served as Parliamentary Secretary at Public Safety for a few years. I also served on the Public Safety Committee for 8 years. And I know one of the things that always struck me was the importance of the separation of the political arm from police investigations. You know, we look at countries around the world where politicians dictate what police do, and we don't want to emulate those countries. And yet we constantly are hearing from the opposition, but also in social media, and that somehow we as politicians should be telling police what they should and should not investigate, who they should talk to. Would you feel comfortable talking just in general terms about the importance of that separation, that police investigations are independent of the political arm of a government?
Well, certainly. I mean, that is my wheelhouse these days, is governance and public administration. And I've written a book on the tradecraft of politics. So the premise of your question, in a free democratic society, it's very important that the justice system operate independently. That includes the police, the prosecutorial service, and the courts. Parliament, you create the framework of laws within which they operate. But in terms of their actual practice of investigations and arrests and prosecutions, those should be conducted fully independently.
And what happens if politicians stick their fingers in and start directing the police?
Well, then you're not in a full democracy. Then you're in the sort of quasi-authoritarian societies that you see around the world. And you can see pressure being put on politicians. This is common practice in the United States Congress. You're seeing hearings where prosecutors and police officials and law enforcement officials are being hauled before congressional committees in the United States. And I think that's a form of pressure and intimidation on the law enforcement system.
Thank you. I remember your testimony back in 2019 at Justice Committee, and at the time, we had been doing Bill C-71 at the Public Safety Committee, and as someone who's advocated quite vocally for gun control, I became the target and have been for a number of years of the gun lobby, which has included threats, memes and all kinds of things on what I think you called the vomitorium of social media, which I still remember that testimony, though, thinking how accurate it was. And since that time, it's only gotten worse, quite a bit worse, actually. And recently, Mr. Barrett posted a video on social media with all of our email addresses, inviting people to contact us about trying to shut down an investigation of the RCMP. And as a result, my staff actually had to open a subfolder in my inbox and labeled it misogyny because of the actual horrific emails and messages I was getting on social media. Do you have any thoughts on the direction that our country has gone in the last few years? I mean, I've been called a traitor. I've been told that the government is corrupt, and I often say to people, take a look at Afghanistan, take a look at what's going on in the Middle East right now. If you actually want to see countries where there are terrorists running a country, as in Gaza, you've got Afghanistan, where women and girls have no rights at all. And it really troubles me when people are making comparisons to other countries around the world, like Russia, comparing Canada to that. And you were your comments then have been proven correct, Mr. Wernick. I've been unfortunately a target of all of those kind of comments. Do you have anything to comment to how we can try to get back to a more civilized discussion on issues?
Well, I think the chair will rein us in as being off topic of today's hearing. I would say that I've given plenty of interviews and podcasts about this topic, and you can find all of my output as a professor on my LinkedIn feed.
Okay, thank you. Then maybe we'll get back to the RCMP, which you're right is the topic of why you're here. And I only have about 45 seconds left. Is there anything that you wanted to add in terms of the importance of the separation of the police, or have we covered it all?
No, I think I've said that. What I would point out to you parliamentarians is that there are issues of ethics and behavior and conduct which do not rise to the law of criminal penalties. And that is why you, Parliament, created other laws and other independent bodies to deal with them. That is why you, Parliament, created the Conflict of Interest and Ethics Commissioner, the Public Service Integrity Commissioner, and the Commissioner of Lobbying, and allocate about $25 million to those three bodies. Sometimes those bodies complete a case and refer an issue to the police. Most of the time they do not.
Thank you very much.
Thank you, Ms. Damoff. And just before we go to Mr. Villemure, I just want to clarify something. At the opening of your comments, you mentioned that you didn't know why, something to the effect that you didn't know why Mr. Wernick was here. And I just want to remind committee members that on October 30th, a motion was passed by unanimous consent to have the RCMP Commissioner, Mr. Pensance, the Ethics Commissioner, former Ethics Commissioner, and Mr. Wernick to appear before committee. And that is why he is here today. And I thank you, Mr. Wernick, for coming before committee. Monsieur Villemure, vous avez la parole pour 6 minutes, s'il vous plaît.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chair. Hello, Mr. Wernick. You explained earlier all of the areas in which you were not a part of this, but what was your role in this affair.
Comme j'ai dit,
As I stated, I appeared before the Justice Committee 5 years ago. There are 4 hours of recordings of what I said to the Justice Committee, and I testified before the Commissioner as well. And I explained everything to the Commissioner and to the committee. You'll forgive me, I wasn't there 4 years ago. So would you be able to give me a reminder? I was the clerk of the Privy Council, so the Deputy Minister to the Prime Minister, up until the Easter weekend 5 years ago. So this is NCC Lavalin, the Prime Minister, and at that time, what was your role? Not your function, I understand, but how did you participate in that series of events? It is very well described in the Commissioner's report. Understood. The Commissioner concluded that there was non-compliance with the code. The RCMP decided not to investigate because there wasn't an infraction to the criminal code, correct? That is what I understand. In your opinion, as having worked at the Privy Council and with your current position, I would like for you to confirm something. Do you believe that an event can be unethical and legal? There are many laws in Canada. There are laws on ethics, on conflicts of interest, lobbying, whistleblowers. There are behaviors that are not a matter of criminal law. So we can not be violating the code while not be violating the act. That was the conclusion made by the Commissioner. Please tell me now about cabinet confidences, because the Commissioner stated that it depends on who's interpreting it. We asked Mr. Pinsins, who said that sometimes they have more access than others. Can you tell us a bit more, please? I'm not sure I understood your question. Can you describe the parameters of cabinet confidences? Because the RCMP Commissioner and Mr. Pinsins stated that it was not always a yes or no answer. There were some murky situations. So where do cabinet confidences start and end? Answer. It's a very important question. It is important to the federal government and the provinces that discussions that occur in the cabinet room be confidential. It has been recognized in many Supreme Court decisions. That's a basic principle. The role of the clerk of the Privy Council has existed for 800 years. And they would be responsible for discussions. The secretary and the clerk of the Privy Council, both roles that have existed for a long time. And one of the roles of the clerk is to safekeep documents and protect the confidentiality of cabinet discussions. There are certain cases where I gave access to certain discussions to the courts or to commissioners. That is one of the roles of the clerk. During your time as clerk, were cabinet confidences assessed on a case-by-case basis? For sharing, you mean? Case by case. So for some topics, we could receive more information, and in other cases, we could decide that no, it was too confidential. For example, in the Norman affair, I gave access to all documents to the judge because the process was governed by a judge and a tribunal. In other cases, we can share a part of the documents with redactions, with names or other elements removed. Apologies for interrupting you. My time is quite limited, but how come there was no disclosure in that case then? It was not my decision. That happened after I left. Thank you very much.
Monsieur Villemure,
Thank you, Mr. Villemure.
6 minutes. Go ahead, please.
Thank you very much. And on the topic of cabinet confidence, you had mentioned that it's a longstanding convention. Is that correct in how you framed it?
About 8 centuries worth, yes.
And how does a convention compare to the laws and principles of parliamentary privilege as it relates to our ability to send for documents and evidence?
There's a role for the clerk which is defined in the Evidence Act, and there are often disputes between Parliament and the executive about the release of documents. You may recall issues around Afghan detainees years ago and so on. So there's always a case by case. It's not an absolute principle. You do not have the right to ask for my medical records or my tax returns.
But to be clear, sir, as it relates to a convention,
yeah.
As I'm to understand, and forgive me for having notes to better refresh my memory or cite the actual laws, but when we were constituted, we carried with us the Westminster system from the UK, and the supremacy of parliamentary privilege supersedes conventions. Conventions are agreements among parliamentarians, but parliamentarian privilege is actually supreme when it comes to the conventions of our abilities in our standing orders as it relates to standing committees to send for documents, evidence, and witnesses.
No, that's your interpretation, and I know it's the interpretation of the law clerks of the House. It's not an interpretation I agree with or the courts have always agreed with.
So who has primacy over the House of Commons, the courts and the clerk, or the members of Parliament?
It's not a question of primacy of one or the other. We have a legislative branch, an executive branch, and a judiciary, and there's tension among the three all the time.
And so within that, in the appearance before the committee, the RCMP commissioner noted about cabinet confidences, that the cabinet confidence is there for a reason. I think the interpretation of cabinet confidence, which as we discussed earlier, sometimes differs from one person to another. So you just mentioned you think that's my interpretation, you have a different one, and the Supreme Court says that cabinet confidentiality is protected as a matter of constitutional convention, which is what you just referenced, or the rules of behavior established by the government institutions that are not enforced by the courts, but are considered binding by those who operate the Constitution. So the people who operate the Constitution are the members of Parliament.
And the police and the prosecutors and the executive part of government. And this is a principle that's binding on all branches of government.
So do you think cabinet confidentiality should be further waived in the context of investigations conducted by the RCMP? Or should this notion of client solicitor privilege, where the government is both the client and the solicitor, provide them a shield from any kind of insight and or I should say oversight for criminal accountability?
It's never that black or white. I think the onus should be to disclose as much as possible to formal legal processes like the police and the courts, but there may always be cases where redaction is appropriate. We're having a discussion now about divulgation of documents involving Chinese intelligence activities within Canada. It would be a very bad idea to simply turn over all the documentation without redaction.
Who decides what's redacted?
The clerk has a role in deciding what cabinet confidences are released on a case-by-case basis.
Who else has roles?
Legal advice to the clerk.
Does the cabinet have a role?
No, absolutely none.
Does the prime minister?
Nope.
And no cases or situations does the cabinet or the prime minister decide what is and what isn't redacted?
If you go back to a previous government, then the previous prime ministers have a role in whether to release documents of their ministry. And basically you sequester the papers of each government when it leaves. So I went back to Prime Minister Harper a couple of times to get his consent to release documents related to the Norman affair because they had happened while he was in office.
So that acknowledges that
he gave that agreement, and we turned over the documents to the court.
And so would that also carry by the same logic that the Prime Minister Trudeau could waive cabinet confidence at any time, despite recommendations by the clerk and by legal advisors?
It's a discussion between the clerk and the Prime Minister. Ultimately, it is the clerk's job
to make the final decision.
Mm-hmm.
Is it ever the situation that staff well below the clerk make decisions on what redactions are?
There would be advice from lawyers and from people like the security intelligence people as to whether redactions were appropriate or not. I always took the view to disclose as much as possible, but you wouldn't want to disclose business confidences or intelligence services or personal names and so on. It's very similar to the process on access to information.
And in your experience, in your years, just to recap, forgive me for not being as familiar as your LinkedIn profile might indicate, but how many years were you in government?
38 years, 17 as a deputy minister.
And in that time, did you see a trend towards more cabinet confidences or less cabinet confidences? Is this a government that was transparent by default, or did they tend to have more instances where they declared a greater volume of work to be in cabinet confidence?
I'm not a historian, but I think the trend line was to be more disclosure. There was a running discussion between the Auditor General of Canada and the executive about the disclosure of documents related to the budget. I reached an agreement with the Auditor General, Michael Ferguson, at the time, and I increased the disclosure of analysis documents related to the budget to the Auditor General.
I believe that's my time. Thank you.
That is, Mr. Green. Thank you. That completes our first round of questioning. On va commencer avec le deuxième tour.
We're going to start our second round with Mr. Berthold, who has 5 minutes, followed by Mr. Housefather. Hello, Mr. Warnick. When did you learn that SNC Lavalin was being a target of an investigation? I do not recall. And when did your interview with the RCMP happen? It was during the summer after I left, and the report came out in August, I believe. So in July, perhaps? I'm not sure of the date. Who were the targets of the RCMP interview after you had spoken with investigators? I do not know. There was a series of questions posed regarding the chronology of lobbying by SNC Lavalin. Did they ask questions on certain ministers? No. When I was interviewed by the RCMP, it wasn't the behavior of ministers that was being questioned, it was the behavior of SNC Lavalin. Well, they can interview people who have to follow the Ethics Act. When you testified to the Justice Committee, the Ethics Commissioner had not completed his report and stated since then that the Prime Minister violated the Act. And the conclusion was that his actions were inappropriate because it went against the rule of law. And Mr. Trudeau infringed upon Section 9 of the Act. You stated at the Justice Committee that Ms. Jody Wilson-Raybould defended, or rather had to make a decision. And do you maintain your position knowing that the Prime Minister broke the law? Apologies, I'm not sure I understood your question. The conclusion of the Commissioner was that he broke a section of the Act, Section 9. And during your testimony, you stated that the Minister had been subject to illicit activities, and the Commissioner had concluded the opposite. The RCMP may have prematurely closed its investigation on the Prime Minister. You were questioned by the Ethics Commissioner, and you stated that regarding the investigation, you were not questioned by the RCMP on the criminal aspects of the Prime Minister. You stated, as the previous minister, I asked what I could or could not say. I was told not to talk about the minister's opinion. And what are the things that you could not talk about at the time? I'm not sure. It was 5 years ago. Miss Wilson-Raybould, before the committee and during an interview, stated that she didn't believe that there were any criminal activities. Mr. Wernick, you have a decision to make. You can shed a light on the potential criminal implication of the Prime Minister, or keep it to yourself. Saying that you don't remember is up to you. History will remember what you say. Why did you try to influence the Attorney General? I have nothing to add to what I've said to the Justice Committee and what I said to the Commissioner during the interview. Do you believe that my question was a threat? That was a question. Is that a question, Mr. Berthold? For Mr. Wernick? Please repeat the question. Did you find that my question was threatening when I talked about the impact on your career as a whole and how you will be judged? No. When a Prime Minister sends his clerk to have a discussion with a minister, that minister knows that the Prime Minister has the ultimate control on their career. Is it normal that Minister Wilson-Raybould felt threatened by how you alluded to the Prime Minister in talking with her? Because that was the feeling. Please, brief response. You have all of that in the Commissioner's report. Thank you, Mr. Berthold.
Go ahead.
Thank you very much, Mr. Chair. And Mr. Chair, I just wanted to personally note, I thought you sent me a very kind note yesterday, and I just wanted to thank you for that.
In the spirit of former Prime Minister Mulroney, yes, I did send that.
Mr. Wernick, first of all, thank you for being here. I think this is deja vu for both of us, having both Mr. Cooper, Mr. Barrett, and myself to ask you questions. But I really appreciate you being here. Can I start by asking, were you involved in any way in the decision of the RCMP to close the investigation?
I've had no contact with the RCMP about any investigation or operations ever.
Tired, and I think that, was there something wrong? My microphone, I don't know what happened. And Mr. Wernick, were you involved in any way in the interactions between the RCMP and the Privy Council office related to the request by the RCMP to waive cabinet confidences, or as you had said, you left in April 2019, you were no longer there?
So before I left, I recused myself from any discussions and decisions about divulgation or keeping of documents. As soon as I was invited to the Justice Committee, I ordered that a hold and retention be put on all documents in the possession of Privy Council office, and I turned over all of those issues about redaction and divulgation to my deputy clerk. And then, of course, I left in mid-April, and after that, that would have been the matter for my successor.
Right. So as I understand, then, in terms of interaction with the RCMP about cabinet confidences, you had nothing whatsoever to do with that, right?
I have no conversations with the RCMP about the SNC level and matter, any aspect of it.
Okay.
Except, as I said, interviewing about SNC's lobbying activities.
Right. I understand. So basically, as you really have nothing much to say about the RCMP's investigation, because of course you would have no personal knowledge of it. I also understand the committee invited you and the clerk properly and the chair properly invited you, but I also don't quite understand why you're here. But while you are, can I ask another question that I've been curious about? When you did the S&C, when the Privy Council office originally determined, and I believe that was before you came to the Justice Committee, so you would perhaps have been involved to determine whether or not there would be a waiver of cabinet confidence to permit Ms. Wilson-Raybould to testify. Was that the largest waiver of cabinet confidence ever when she was permitted to divulge matters to the Justice Committee and others would be within a certain scope?
I'm not sure I can answer that authoritatively. There were two large ones that I'm aware of when I was clerk. One was to the Norman trial, and the other was the waiver for the Attorney General.
And can I ask, I know Mr. Green sort of got into this, but what would be the considerations that you would give in terms of determining as the Privy Council office whether or not to grant such a waiver? How would you balance public interest versus confidentiality, et cetera?
Well, there is a public interest in the confidentiality of cabinet discussions. It's how we make cabinet work. So there's a large public interest in maintaining the convention and the practice of cabinet confidentiality. And then there may be a specific public interest in an inquiry or a trial or criminal proceedings or something like that. And so that's the judgment that has to be exercised about weighing one public interest against another public interest. And
would that be different when you have a request from a police force doing an investigation versus some other type of request, such as a request from a committee of parliament or a request from somebody else?
Well, I think there would be a little bit of a judgment in terms of whether the information would be kept in confidence by the person receiving it, what they would do with it. There's a very structured process by a commission of inquiry, like the one that's underway now. There's a very structured process if you give it to the courts, and the courts operate under various laws and practices. And there's practices by parliamentary committees. So I think and then there's just public disclosure, putting stuff out on the internet. So yes, it would certainly have some bearing in terms of what would happen to the documents if they were used. I always took the principle of to disclose as much as possible if it was part of the justice system, courts, officers of parliament, tribunals, investigations, commissions of inquiry, and so on.
I appreciate that. Am I done, Mr. Chair?
3 seconds, Mr. Housefather.
Thank you, Mr. Chair. I cede it back so that Mr. Cooper gets extra time, or whoever's next. Peut-être M. Villemot peut avoir 30 secondes.
Oui, j'ai donné un peu plus de...
I did give extra time for Mr. Berthold, but it was 20 seconds. Mr. Villemot, you have 2.5 minutes. Thank you, Mr. Chair. Mr. Warnick, with all due respect, always mentioning the 5-year-old report and evading responses or not remembering is not good enough for the committee. I would like to ask you the following question. In the discussion that you had with Ms. Wilson-Raybould, you said, I believe that the Prime Minister is not asking you to do anything inappropriate or to interfere. He is asking you to use all of the tools at your disposal legally and etc. I would like your comments on that, please. You have the interpretation made by the Commissioner. Yes, but I would like your response. I don't have anything to add. That is not good enough. I don't have any additional questions. One moment, Mr. Villemot.
You're an experienced government employee. You understand that your appearance before committee is protected by parliamentary privilege. Members have privilege to ask questions, and they expect that they're going to be directly answered. So my expectation as the chair on behalf of this committee, Mr. Wernick, is that you're going to answer those questions. Monsieur Villemot, 1 minute et 45 secondes. Recommence, s'il vous plaît.
Merci, Monsieur le Président.
1 minute, 45 seconds. Thank you, Mr. Chair. Mr. Warnick, on what was quoted earlier, that the Prime Minister wasn't asking to do anything illegal, but to use any tools at the disposal of Ms. Wilson-Raybould, there was some hesitation. There's some things that are unsaid in there. I would like your comments on that discussion, please. From whose perspective? You stated, I don't believe that the Prime Minister is asking you to interfere, do something illegal. He's asking you to use the legal tools at your disposal, which could lead someone to believe something. What is that? I don't know. I don't have any other questions.
See, Monsieur,
Thank you, Monsieur Villemur.
to Mr. Green for 2.5 minutes. Mr. Green, I'm going to start you again. You're on mute. Go ahead.
You're very gracious. Thank you very much. I'm just going to pick up on that. I wasn't around, obviously, when this happened. Certainly, the Honorable Murray Rankin and Charlie and others from my caucus likely would have dealt with this. So help me just get a sense for, when the telephone conversation happens between you and the former Attorney General, and you say the Prime Minister is in a kind of a mood, and there's an assertion that he wanted her to shelf the prosecution, and it says in quotes that he's in a pretty firm frame of mind about this. So I'm a bit worried. What would you be worried about? This is your language from the recorded conversation.
Yeah, you're asking me to dredge up memories from 5 years ago, and I gave my testimony on all of this to the Justice Committee and to the Commissioner. To the best of my recollection, this was an issue about the minister's role as a member of cabinet and the
Point of order, Chair.
Cabinet as a team.
Point of order.
Hang on a second, Mr. Wernick. Mr. Barrett, on your point of order, please.
Chair, you intervened in the previous round with very clear expectations about what's supposed to happen. Mr. Green's question was very straightforward to the witness, and the witness is now saying that he gave testimony about something that hadn't happened at the time. When he came before the Justice Committee, the recording that Mr. Green is referencing hadn't yet been released. Mr. Wernick didn't know he'd been caught. And so the expectation of the committee, of course, is, as you said, that the witness is going to answer the questions, not simply say, I've answered that question before. However, Chair, for your consideration, of course, committee can formally order that the witness answer the questions, and if he refuses, then it is a violation of this committee's privilege, which would need to be reported to the House. But I don't think it needs to come to that, but just think that perhaps one more urging and an opportunity for Mr. Green to restate his question so that we can get an actual answer from the witness.
Okay, thank you for that intervention, Mr. Barrett. That is a valid point of order. Mr. Wernick, I am now starting to get into one of those moods that you spoke of with the Prime Minister. I'm asking you to answer the questions directly. Mr. Green, I'm not going to start your clock, restart. I'm going to ask you to restate your question, and the expectation of this committee, because they do have privilege, Mr. Wernick, to ask these questions is for you to answer them. So, Mr. Green, go ahead. I'm going to give you as much time as you need.
Thank you very much. And this was referring to the December 19th, 2018 conversation that had been recorded when you told Ms. Wilson-Raybould that Mr. Trudeau was in a kind of a mood and, in her words, wanted to shelf the prosecution of the Montreal-based engineering firm. And I quote, these are your words as recorded and distributed, he's in a pretty firm frame of mind about this, so I'm a bit worried. And then you go on to say, I'm worried about a collision then, because he's pretty firm about this. I just saw him a few hours ago, and this is really important to him. So I raised that, sir, because in the context of previous testimony you just provided in this committee, you talked about feeling intimidated, or maybe not you feeling intimidated, but where that line could be crossed. But yet, as was mentioned earlier, when you are sent a messenger from the Prime Minister's office that talks about a mood, that talks about a collision course, like, what did you mean by that?
So first of all, I'm trying my best to respond to the questions and reconstruct a sequence of events. I apologize to the members if I've got events of 5 years out of sequence and whether my testimony, which happened twice, was before or after other events. I don't have the chronology clear in my head. So if I mixed it up, I apologize to the committee. You're talking, I presume, about my first appearance at the Justice Committee? Or are you talking about the...
I'm talking about the recording that came out.
Yeah.
And I would say that it's a lot easier for you to operate in this committee if you just answer the questions. Then you don't have to think about what you did, and you don't have to think about timelines. Just answer.
Well, actually, the timelines matter to the answers. So yes, I do want to know the sequence of events.
December 19th, 2018.
Right. And that conversation was available to the commissioner. So I'm not sure what your question is again, still. I'm trying to answer it. What is your question?
You said the Prime Minister was in kind of a mood and that the Attorney General was in a collision course. I'm going to put to you, sir, that sounds like a threat. That sounds like when you say that you arrived from meeting him a few hours ago and you came to her with that message, that sounds like a threat.
Certainly was not intended as a threat, and it's not the interpretation of the commissioner.
Those are my questions.
Thank you, Mr. Green. Mr. Cooper, for 5 minutes. Go ahead.
Thank you, Mr. Chair. Thank you, Mr. Wernick. 2 days before Jody Wilson-Raybould testified before the Justice Committee, you drafted Order in Council 2019-0105 that partially waived cabinet confidentiality, correct?
No. I had left all of the issues about confidences and divulgation to the deputy clerk, so she would have supervised the drafting of it. It's possible I signed it off as the clerk.
No,
I don't remember.
You had no involvement whatsoever. You had no conversations with the Prime Minister, and the deputy clerk had no conversations with the Prime Minister?
As soon as I was invited to the Justice Committee, I stepped back and recused myself from all of the issues around document production.
You recused yourself entirely. Okay. So you wouldn't be able to comment, for example, on why the order in council was drafted in a way that prevented Jody Wilson-Raybould from providing her full version of events?
I did not participate in the drafting of it. I'm sure we would have been trying to strike some sort of balance between the confidentiality of those cabinet meetings and Ms. Wilson and the specifics that Ms. Wilson-Raybould was going to be asked to testify about.
Jody Wilson.
I did not participate.
Jody Wilson.
I didn't participate in the drafting of that order.
So is it accurate to say that you recused yourself entirely from the drafting of that order in council and any discussions that may have taken place about expanding the scope of that?
Point of order, Chair. I understood that we were meeting today to talk about an RCMP investigation. That was
to the very heart of that issue.
Hang on, Mr.
So I've got the floor, Mr. Cooper. But so rehashing something that happened 5 years ago that has been subject to numerous meetings of a whole bunch of different committees in Parliament. We're talking about the RCMP, and none of these questions have to do with an RCMP investigation, which my understanding, Mr. Chair, you brought that he was here to talk about what the motion was with regard to. Maybe we could just stick to that.
You were asking about my Twitter in the last round.
Michael, just hang on a second. Thank you for that, Ms. Damoff. I appreciate your words. Mr. Cooper, you have the floor, and you can continue on this. And I did stop your clock, and I expect that you're going to come back.
I expect Mr. Wernick to answer the question that
I
asked.
Go ahead, please.
Sorry, I lost the thread. What was the question?
Stop my clock.
Go ahead, Mr. Cooper.
I asked you, Mr. Wernick, before I was interrupted, to clarify that you had, from the time that you had appeared at the Justice Committee, that you entirely removed yourself from discussions concerning the scope of the order in council and any further discussions or consideration of expanding the scope of that order in council.
That's correct. And everybody concerned was interviewed by the commissioner in the months that followed.
And to Ms. Damoff's point, it is of relevance to the issue of an RCMP investigation because we heard testimony from the RCMP that the central or strongest theory towards establishing obstruction of justice was whether the Prime Minister removed Jody Wilson-Raybould to get an Attorney General who would make a decision the Prime Minister wanted, and that the RCMP was impeded by their investigation to determine that as a result of the parameters of that order in council. Mr. Wernick, when you appeared at the Justice Committee back in 2019, you characterized your interactions and those of the Prime Minister and his officials with the Minister of Justice, Jody Wilson-Raybould, as so-called lawful advocacy to appropriately raise public interest considerations to the minister, particularly that SNC would move its headquarters from Montreal, resulting in the loss of at least 9,000 jobs. I'm going to ask you, what evidence did the government have that SNC-Lavalin would move its headquarters from Montreal if a deferred prosecution agreement was not entered into?
I think we went over this at the Justice Committee. There were representations by SNC, and there were public statements made by SNC, and there were market disclosures by SNC.
Mr. Wernick, you must have known that SNC had a financing agreement with the Caisse de Depot that required it to maintain its headquarters in Montreal for another 6 years until 2024. It was public knowledge that SNC had entered a 20-year lease at its Montreal headquarters. It was also public knowledge that SNC had announced major renovations to its headquarters in Montreal worth millions. And 2 days before your infamous December 19, 2018 telephone call with Jody Wilson-Raybould, in which you specifically raised the issue of the 9,000 jobs and SNC moving its headquarters,
hang on, Mr. Cooper. Go ahead with your point of order, Mr. Chahal, and I'll just advise you that it's been practice in this committee that I've given members their time to ask questions on a broad range of things in relation to this. If it's to object to the line of questioning to Mr. Cooper.
Mr. Chair, I haven't even made my point of order yet, so I'm not sure what you're objecting to.
Go ahead. I'm not objecting to anything. I want to hear what you have to say. Just hang on, Mr. Cooper, please.
My line of questioning.
Now, Mr. Cooper is interrupting my point of order, which I have not had the opportunity to make.
Chahal. Go ahead. Go ahead.
So, Mr. Chair, I would like the opportunity to present my point of order. I'd asked Mr. Cooper the relevance of his questioning, and once again, you have not let me finish, Mr. Barrett. You're not the chair.
Yeah.
Mr. Barrett, you're not the chair. If you let me finish,
Mr. Chahal, I know which direction you're going.
Well, you do not, because I haven't finished my sentence.
I do know which direction you're going on this.
All I would like to do is say the relevance to the point of order that Mr. Cooper, on your questioning with the RCMP.
Line of questioning.
Hang on. Michael and Michael.
I presented my point of order.
I want Mr. Chahal. I want you to go through the chair on this. Okay, don't go through Mr. Cooper.
Thank you.
So you have a point of order that you're raising. State your point of order succinctly, please.
Yes.
And then we'll go from there.
So if I'm allowed to do so, I will raise my point of order succinctly. I'd like to know what the relevance of the questioning provided by Mr. Cooper is, because this has nothing to do with the RCMP.
Mr. Chahal, I've been chairing this committee now for 18 months, and in every circumstance that we've had discussions at this committee, I give members a broad latitude to discuss and ask questions that they feel are relevant to the situation, with the expectation that they're going to bring it back. So you're not issuing a point of order. Your point of order is actually very subjective. So, Mr. Cooper, you have the floor. Go ahead, please. You have 53 seconds. Thank you for your point of order, Mr. Chahal.
None other than 2 days before your infamous phone call with Jody Wilson-Raybould, in which you raised the issue of jobs at SNC moving, the CEO had publicly stated that SNC-Lavalin was committed to staying in Montreal. So why did you tell Jody Wilson-Raybould that jobs were on the line and there was a risk of SNC moving its headquarters when you had to have known that that simply wasn't true?
That was my understanding at the time, and that the law that Parliament created in terms of deferred prosecution agreements.
How is it possible that could have been your understanding at the time in the face of everything that I laid out?
Let him finish, please.
Will you let me finish? You're badgering.
Your answer is simply
point of order.
Mr. Cooper.
Point of order.
Thank you, Mr. Cooper, for your line of questioning. That concludes your time. We're going to now go to Mr. Baines for 5 minutes. Go ahead with your point of order, Mr. Chahal.
Once again, I just want to acknowledge the witness is here to answer the questions, not to be interrupted by the member asking the questions. So if you ask a question, allow the member, allow the witness to provide an answer. And I'd ask Mr. Cooper to
thank you. I get the
apologize for rudely interrupting the witness in the middle of his questioning.
I get
an
the
answer.
gist of what you're saying, Mr. Chahal. We're going to proceed with Mr. Baines now for 5 minutes. Go ahead. Thank you.
Thank you, Mr. Chair, and thank you, Mr. Warnick, for joining us today. Do you think that cabinet confidentiality should be further waived in the context of investigations conducted by the RCMP?
Generally, there should be a maximum of disclosure, but it would be a case-by-case determination.
Okay, and would you agree that in this case, with waiving cabinet confidence in regard to the SNC Lavalin situation, that this represents one of the largest and most expansive waiver of cabinet confidences in Canada's history?
I don't know which documents were divulged and which were redacted and which were retained, so I don't really have a way of judging that against other productions of document issues.
And you said you've had a career of 38 years. Do you know how many times cabinet confidence has been waived in the past in the context of a potential criminal investigation?
I don't have a specific number of that. It usually would have been in the case of criminal investigations, commissions of inquiry, structured processes. The one I'm most familiar with is the Norman trial.
Sorry, I didn't catch the last. The normal.
Admiral Norman,
okay.
trial. Normal trial. I authorized a very large disclosure of cabinet papers from the Harper and Trudeau governments to that trial.
How large?
I don't remember. That was about 8 years ago.
Okay, and during your testimony at Justice Committee in 2019, you stated that the independence of the investigative and prosecutorial function has never been compromised. Do you still agree with that statement?
Actually, that's a statement by the Director of Public Prosecutions.
Okay, the Ethics Commissioner interviewed a long list of staff, officials, and we heard from the RCMP Commissioner that the Ethics Commissioner has more access than even the RCMP. And if there is a criminal wrongdoing or wrongdoing of any kind, then the Commissioner must stop and hand over findings to the RCMP. Is this your understanding of the rules around disclosure?
I don't have anything to rely on right now except memory, but yes, that would be my understanding.
And are you aware of the number of people that were interviewed?
No. I've never had a conversation with the RCMP about any investigation or any operation ever.
How about the Ethics Commissioner?
I was interviewed by the Ethics Commissioner in the summer of 2019.
Okay, how much time do you have? 2 minutes. In his appearance before the committee, the RCMP Commissioner Mike Duham noted that the following about cabinet confidences, quote, cabinet confidence is there for a reason. I think the interpretation of cabinet confidence, which we had a discussion on earlier, sometimes differs from one person to another. Recently, the Supreme Court of Canada stated, quote, beyond legislation, cabinet confidentiality is protected as a matter of constitutional convention or the rules of behavior established by government institutions that are not enforced by the courts but are considered binding by those who operate the Constitution. What is your interpretation of cabinet confidentiality and why is it important?
The Westminster system of cabinet government relies on the confidentiality of cabinet discussions, that ministers can speak freely among their colleagues, and then they're bound by the decision that's called, and they are bound by cabinet solidarity as a consequence of that. If you were operating in the open like a city council, then people would behave like a city council. There would be far less candor within the cabinet room. So that's the software on which Canada, federal and provincial governments run. It's been acknowledged as such by the Supreme Court. That creates tensions between different branches of government, and the courts will decide on that. The general framework has been set by the Supreme Court in more than one decision, and it's been set by the federal court in some specific cases in terms of arguments about specific documents and specific redactions.
That's all I have. Thank
Okay,
you.
thank you, Mr. Baines. That concludes our first hour of questioning. We're now going to proceed to the second hour, which means we're going to reset the clock. And just a reminder to members that if there is an intervention, then a point that needs to be made, that it comes through the chair. I don't want to have banter back and forth between members. And I'm also going to remind members as well that relevance is subjective. And so I believe that members have their time to ask their questions. I also expect, as I said earlier, that members are going to come back to the point. So if you're interrupting because you don't like something you're hearing, that's too bad. Mr. Brock, you have 6 minutes. Go ahead.
Thank you, Chair. Mr. Wernick, the focus of my time with you will be on the concept of two-tier justice, two-tier level of justice. But before I get to that, today being March the 19th, when were you invited? When did it come? When were you known that? When did you know that you were going to be invited to this committee?
Oh, I don't know. It was about a week ago, I think.
About a week ago?
I can check my emails, something like that, yeah.
Okay, and then in the past week or so, what did you do to prepare for this meeting?
Just me and Google search.
Just sorry, what?
Just me and my Google search. I haven't spoken to anybody about this appearance.
No, that wasn't the question. How did you prepare? Did you review, for instance, your 2 transcripts of previous testimony at the Justice Committee?
I read the commissioner's report, and I downloaded and read the 2 committee appearances, and I did a search for news articles.
Okay, that's a good start. Now, we know that the ultimate conclusion from the Dion report is that the Prime Minister directly and through senior officials used various means to exert influence over Jody Wilson-Raybould. The authority of the Prime Minister and his officers were used to circumvent, undermine, and ultimately to discredit the decision of the Director of Public Prosecution, as well as the authority of Jody Wilson-Raybould as the Crown's Chief Law Officer. I'm going to quote from her book, Indian in the Cabinet, that she says, "The efforts to pressure me either directly or through Jessica continued from September the 17th and onward. Ultimately, 11 officials from the Prime Minister's office, the Privy Council office, and the Office of the Minister of Finance made attempts. Over that 4-month period, there were approximately 10 phone calls, 10 meetings about SNC-Lavalin, culminating in a phone call I had with the clerk of the Privy Council on December 19th. Now, you didn't know that you were being audio taped, did you?
No.
No. And unlike yourself, because I did review with some great scrutiny your previous transcripts and your evidence from the Justice Committee, you didn't take contemporaneous notes, unlike Jody Wilson-Raybould, did you, of all your interactions with her?
No.
So there was nothing that you could use to refresh your memory in advance of your appearance at Justice Committee 4 years ago, 5 years ago.
Between December and my appearance in February, no.
Yes, okay. Now, in your opening statements, I don't know if it's your first or second testimony, you talked about two-tier level of justice, but only in relation to the fact that SNC-Lavalin eventually did not receive the DPA and ultimately, as we know, pled guilty to 1 count of fraud. So that's not the focus of the question. The focus is, in my view, there is a perception among Canadians and a perception among numerous members, myself included, that there was a political non-appetite by the RCMP to conduct a thorough investigation. Prior to the commissioner's attendance, not too long ago, they had roughly close to 4 years of investigating this particular matter. And unlike the ethics commissioner, who essentially interviewed 14 witnesses, you being included, the RCMP interviewed 4. Now, I know you've already opined that you're not going to talk about police operations, but given that discrepancy, do you think that there is a disconnect between in terms of how the Ethics Commissioner approached this investigation versus the RCMP?
The Ethics Commissioner's mandate given to it by Parliament is about violations of the Conflict of Interest Act. And the RCMP would be looking at a threshold of potential violations of criminal law. So they would be looking at it with a different lens. But it is entirely up to the RCMP whether they pursue preliminary investigations, fact-finding, final investigations, or move on to laying of charges. That's their job.
But the evidence is still the same. The evidence, and the RCMP confirmed it, that they relied upon the evidence received from the Ethics Commissioner. The Ethics Commissioner was ultimately stymied and was upset that he was unable to complete a fulsome report due to the actions of the Prime Minister, which is exactly the same rationale the RCMP had used in closing up their investigation because they could not obtain further information from the Prime Minister. Were you aware of that?
So I'm aware that that's what the Commissioner wrote in his report. Yes, of course.
Now, there's two elements to any criminal charge. The RCMP were investigating obstruction of justice and intimidation of a justice participant. There's two elements. There has to be an act and there has to be a mental element, an intention to complete the act, known as actus reus, mens rea. I don't want to get into legal complexities, but that is the ultimate test. Did you review the testimony of the RCMP Commissioner from a few weeks ago?
No.
All right. Now, I'm going back to some of the evidence that...
I'm sorry, Mr. Brock, you get like 10 seconds
I got
left.
no time.
Okay,
Thank you.
thank you. Mr. Sabera for 6.
Thank you, Mr. Chair, and it's great to be on this committee today, and happy Tuesday to everyone. To Mr. Warnick, thank you for being here with us today. Mr. Warnick, when did you leave government, please?
Easter weekend of 2019.
And can I ask how long, because I do want to get this on the record, and you may have stated this early, how many years did you serve in the public service and in what capacity?
38 years in the public service, 17 years as a deputy minister, 3 years as clerk.
And I take it over those 38 years period, you served both under administrations or governments of both of liberal and conservative stripe.
Indeed, I'm very sad to see Mr. Mulroney's death.
Yes, I'll state this and hopefully state it later on this evening that Mr. Mulroney was a transformative Prime Minister for Canada and the Prime Minister for the time, as I will reflect on his many achievements that we've heard about and been reminded of in the last few days. Mr. Warnick, I can only say that, you know, being a former clerk of the Privy Council and secretary to the cabinet, that your responsibility level and what you carried on your shoulders was, in fact, a very high bar.
Thank you, sir.
Thank you. And I take it today, in what capacity are you operating in? Are you just fully retired, or are you still contributing to Canada and to our society?
I'm a part-time university professor. I have an endowed chair and I dabble in public administration, governance, public sector productivity, management issues. My output is on the LinkedIn site that I maintain. Yes, of course. And the Jarzowski, the endowment chair, and anyone knows in the investment world, the Jarzowski, the individual, what they've done for Canada is actually quite exemplary. Going to... he's still alive. I should hasten to add he's still alive. Yes, much so. Going to the question at hand, and then we've had a lot of questions. In fact, I think today we've had the same questions from some of my colleagues on the opposite side, that the same questions they asked today were the same ones they asked in 2019, because there really isn't anything new here that we needed to look at. But in terms of cabinet confidentiality, you've obviously been in that cabinet room under governments. How important to that, and how complex is that? If I had to explain it to, you know, the voters back at home in Vaughan Woodbridge, the importance of cabinet confidentiality and what that means, can you elaborate on that, sir? It's a big topic. We run cabinet government. You are elected as a team. You will be unelected as a team. And people are chosen to sit around the cabinet table among the caucus of the governing party, maybe more than one party if there's a coalition. It's a fundamental principle that people can go into the room and speak freely about their views on any topic, whether they're presenting their own ideas or discussing ideas presented by a colleague. They are elected as a team and then they stick to the decision. Once a decision is called, that is the decision of cabinet, which goes forward in terms of laws, policies, and regulations. We do not operate the federal or provincial cabinets, as you know, like a city council where everybody has an independent voice, or the American Congress where everybody has an independent voice.
Independence, your quote on the rule of law in 2019, your first appearance, and this was 2019, probably almost 5 years ago or so, and you stated, should Canadians be concerned about the rule of law in this country? No. In the matter of SNC Lavalin, is now 7 years since the first police action on the company, and 4 years since charges were laid by RCMP, and during that entire time and up to date, the independence of the investigative and prosecutorial function has never been compromised. The matter is proceeding. And that independence of the judiciary in Canada, from your point of view, the robustness of that independence and how that worked under the time you served as the clerk of the Privy Council, please.
Well, I would stand by that commentary. It's the Director of Public Prosecutions who said at the time and went to the trouble of issuing a statement that her office had never experienced political interference in a prosecution. And we have not seen interference in police investigations, as tempting as it would have been in the case of blockades and pipeline blockades and the occupation of downtown Ottawa. It's a well-established principle at federal and provincial governments that police investigations and operations are conducted independently, prosecutors operate independently, and courts operate independently.
Yes, and as not even just as a member of Parliament, but as a citizen of this country, a Canadian citizen, we would expect nothing less than that independence to be upheld at all times.
Well, you see what happens in other countries when you start to see the government directing who should be investigated and who should be arrested.
Yes, and it is unfortunate to see that happening in other countries. I know, and here in Canada, we must guard always to ensure that the independence is upheld. And I thank you, sir, for those comments. Mr. Warnick, I just want to say thank you for your 38 years of public service and your duty and responsibilities that you held for both governments, whether it was a Conservative government or a Liberal government. Your service speaks for itself, and I want to say thank you. Chair, I'm finished with my remarks. Thank you.
Mr. Sabera, Monsieur Villemure, pour 6 minutes, s'il vous plaît.
Merci, Monsieur le Président. Monsieur Warnick.
Thank you, Mr. Chair. Mr. Warnick, as mentioned earlier, we are here today because of a motion regarding why the RCMP did not carry out an investigation. We've heard from the RCMP and those responsible for the investigation. And we've all wanted to ask you a question regarding cabinet confidences. I understand the use of cabinet confidences, being able to share opinions without being afraid of having one's head ripped off. When you decided not to disclose documents at the time, I would like to know why. As I stated, I did not participate in the decision of sharing documents. The decision was made by my successor. All right. If I come back to when you were clerk and a hypothetical situation where you would have had to decide on a disclosure of documents, what would you have based yourself on to decide whether or not to disclose some documents in part or not at all? I did not participate. These decisions need to be seen as independent and nonpartisan. That is why, because I was immersed in this at the time, I could not be seen as independent. And as I said in response to another question, if it is a commission of inquiry or if it's a criminal investigation, we should give access to as many things as possible. you were a clerk who did not participate in the decision, but you were in function for a while, and you stated the reasons why cabinet confidences might be disclosed. It does depend on the use of those documents and protecting information. Do you believe that parliamentarians should have access to these documents? I believe that it's not a clear-cut case. There are cases where redactions would be necessary. For example, for intelligence or foreign information, personal information. Yes, there is parliamentary privilege, but you can't ask for information from my doctor, for example. I think that there's a matter of relevance, of course. I would like to explain where my question comes from. In the case of a lab in Winnipeg, we received 400 pages of documents that were redacted, and when I participated in this, it was preventative redaction, over redaction, in fact. In certain cases, do we tend to not disclose because we're afraid, or do we over redact? And in the Winnipeg case, it was going from completely redacted to not so redacted. I think it's a case-by-case matter. And when we're talking about information given by a CSIS, and when we talk about foreign interference, I believe that in those cases, there needs to be a balance between transparency and protecting this information. In the SNC-Lavalin case, it wasn't a matter of national security. And so we're wondering how we can see the cabinet confidences as well as the need to know of parliamentarians. This is the main issue here, because the RCMP commissioner stated not having access to all the information, and because he didn't have access to all that information, no charges were laid. But as parliamentarians, we have to see who decides the balance between the necessity for secrecy and transparency. You worked for such a long time in the public service, and your point of view is important. It really has to be a case-by-case basis. Balance between confidentiality, public interest. I'm not sure if I can explain these principles clearly. I have always tried to disclose the most documents as possible, depending on the investigation, criminal investigation. Thank you very much. I always think about this when I think about the Winnipeg lab case. 400 pages and 0 pages. I'm very concerned by over-redaction that doesn't allow parliamentarians and Canadians to understand. In the case at hand, if this were to happen again, would you make the same decisions regarding conversations with Ms. Wilson-Raybould? Would you do anything differently? This is quite hypothetical. I don't see it as quite relevant. I always look forward, not back. Mr. Villemur, you have 30 seconds. Retrospectively, Mr. Warnick. Thank you.
Green for 6, go ahead.
Thank you very much. Mr. Warnick, picking up from our last exchange when you suggested that Commissioner Dion didn't come to the conclusion that there was a threat or an act of intimidation between yourself as an emissary of the Prime Minister to Ms. Jody Wilson-Raybould, I refer to the Warnick report, page 3, paragraph 14, when it is stated that on the basis of the evidence gathered, he concluded in paragraph 285 of the Trudeau II report that individuals who acted under the direction or authority of the Prime Minister in this matter could not have influenced the Attorney General simply by virtue of their position. My reading of that says not necessarily that that didn't happen, but that by basis of your position, the Commissioner didn't believe that you were in a position to provide that influence on the Attorney General because you were not the Prime Minister. So that's a bit of a different reading. What's your response to that?
Well, Parliament created the commissioner to make these judgments of interpretation, and that's his interpretation.
And so it's based on the evidence gathered, and we're here today because there's a thought that perhaps not all the information was present. Would your understanding be that the commissioner would have had access to all the information necessary to make that decision?
I don't know. I mean, my conversation with the Attorney General was a matter of public record before he completed his report.
You had referred on multiple occasions that, almost as a warning, that a scenario where the government directing the police leads to an authoritarian culture. Is that an appropriate summary of your remarks?
I think that it is very important in a free and democratic society that the police make decisions about operations and investigations independently.
And when they don't, how would you I believe you characterize that as being authoritarian, correct?
I think it's what what we see in partial democracies and authoritarian countries, and you can look at the headlines in a number of countries, Poland, Turkey, Russia, others, where directing or intimidating the police in terms of who they should investigate, who they should arrest, who charges should be played. That is not a full-blown democracy.
And what would your opinion be for the same scenarios where pressure is applied to the prosecution and not the police?
Same thing. I mean, that's why that is why the Harper government created an independent director of public prosecutions. That only dates from 20 years ago, and that was created specifically to ensure the independence of the prosecutorial service.
Why did you resign?
As I said in my letter, I felt I couldn't do the job anymore.
Okay. I think that's all that I have. Thank you.
Okay, thank you, Mr. Green. We're going to go to Mr. Barrett now. Mr. Barrett, because that concluded our first round, so we are on 5-minute rounds. Mr. Barrett, go ahead, please.
Do you own shares in SNC-Lavalin?
I don't own shares in anything.
Have you ever owned shares in SNC-Lavalin?
I've never shown shares in anything. I was covered by conflict of interest rules.
As someone who specializes in governance, what do you think about cabinet confidence being used to hide wrongdoing and shield members of the executive from effective investigation by police?
If that was the case, then that's not a very good idea. Not a good thing.
So we've had the RCMP before parliamentary committees tell us that they have not been able to productively pursue investigations because of the executive's refusal to waive cabinet confidence. So you would characterize that as what? You said not very good?
Depends what the confidences in question were and what they would have led to.
I think that we know that in these cases they would have led to charges being laid against Justin Trudeau, and that's why. That's your
hypothesis. We don't know. I don't know what was redacted, what was withheld, and what was produced.
Indeed, we don't know because the executive has used their power. The Prime Minister has used his power to shield himself from effective investigation by police. It creates a real problem when we don't know what we don't know. We don't know. We don't have anyone who watches the watchers, including our federal police. And on that, in a previous response, you said that when politicians start meddling in the justice system, it's not full democracy, it's authoritarianism. But that's what we saw with SNC-Lavalin, isn't that right?
Well, where was the interference with the justice system?
Well, sir, welcome back from 2019. I know that you had a front row seat at the time. We had the Prime Minister who was found to have used his influence to pressure the Attorney General. That's a finding of an independent officer of Parliament. That's not my opinion. We know this to be a fact, and we know that you, sir, on doing the Prime Minister's bidding, doing Justin Trudeau's bidding, in an extended phone call, put tremendous pressure on then Attorney General Jody Wilson-Raybould to do exactly what the Prime Minister wanted, and that was to give a deferred prosecution agreement, or for the uninitiated, effectively a get-out-of-jail free card for a liberal-friendly firm, friends of the Prime Minister. And that's pressure. And what happened when Ms. Wilson-Raybould didn't do what she was supposed to do in the Prime Minister's estimation? She was kicked out of cabinet. And when someone spoke up on her behalf, they were kicked out of cabinet in Dr. Philpott. And for their dissent, they were both ejected from caucus. So it seems like that's a pretty heavy hammer the Prime Minister was able to carry. And what did he do? He put in a Justice Minister who would do what he wanted to have done, to do his bidding. That is, as you described it, authoritarian, because that's exactly the kind of interference in the justice system that happens in tin pot dictatorships.
So that's one narrative. Another narrative would be that the maximum pressure put on the Attorney General was to provide reasoning and rationale why she declined to use a tool, an entirely legal tool that was provided by Cabinet, the Deferred Prosecution Agreement, which was made available for certain cases. Deferred prosecution agreements are not an illegal act. They are a legal tool. It's how we got the two Michaels back from China.
Yeah, no one has said that a DPA is illegal. What we're saying is that the Prime Minister inappropriately interfered in the administration of justice in this country. And someone who would be willing to do that can't be trusted to, of course, protect themselves from prosecution by the RCMP for obstruction of justice using powers of the executive. That's blatant interference. Do you have any regrets about how Jody Wilson-Raybould was treated?
Not every issue of ethics or behavior rises to the level of a breach of criminal law. That is why Parliament created a Conflict of Interest and Ethics Commission.
Regrets, sir. Do you have regrets about how Ms. Wilson-Raybould was treated?
I have no regrets about anything that happened. We all made our best decisions at the time with the information we had, everybody involved in the affair.
Thank you, Mr. Barrett. Ms. Damoff, for 5 minutes. Go ahead, please.
Thanks, Chair. Mr. Warnick, can you maybe, gosh, I don't even know where to start after that line of questioning. You know, we're here to talk about why the RCMP didn't lay charges. Maybe I'll start with, if you could explain again the difference between what the Ethics Commissioner does and what the Royal Canadian Mounted Police do.
Well, I'm not an expert on the RCMP. I've never worked for them, and I've never worked at public safety, but they are the federal police force. They're also a community police force in many parts of the country, as you know. But in terms of them acting as a federal police force, they are there to investigate and pursue violations of almost any federal crime. So it could, largely it's criminal law, but there are other laws that they would act as the enforcement body on. So they are often made aware of things through complaints or referrals or whatever, and they would have preliminary fact finding. They might pursue a more detailed investigation, and they might decide to refer it to the prosecutor for the laying of charges. Those are decisions made within the police force.
And then the Ethics Commissioner it doesn't follow that a finding of the Ethics Commissioner in turn results in charges being laid by the RCMP, right?
No, Parliament over the years created a number of watchdogs and investigative bodies to look at the enforcement of other laws. The ones that are relevant here, I would think, are the Conflict of Interest and Ethics Commissioner, the Public Service Integrity Commissioner, and the Commissioner of Lobbying. Not every issue of ethics and behavior rises to the standard of breaching criminal law. And I would remind you that the Attorney General said on more than one occasion, she didn't think that criminal activity had taken place.
Thank you. you've been under, the questions have been rather fierce directed towards you, Mr. Wernick, about your time when you did serve as a public servant. My experience with the public service is that they're nonpartisan. They're there to carry out the policy that Parliament direct. We pass laws. The public service implements those laws. But my experience, and I just wondered if you can comment on this, is your role was not to be partisan and to do, as Mr. Barrett just said, Justin Trudeau's bidding. Is that correct?
I was deputy minister to the prime minister, so I was there to support him in all of the roles that a prime minister plays. I've been before parliamentary committees of the House and Senate probably 30 times, and this is the 6th time since I retired. So I'm not intimidated or worried about helping Parliament do its job.
But I guess my question was, is the public service partisan? Most public servants serve through different political parties and are doing so in a very professional way, not being partisan. And I'm thinking not just of the separation with the RCMP. I look at Correctional Services of Canada, where they carry out, they follow policies put in place by the government, and they're doing it in a nonpartisan way. And is that an accurate description of our public service?
Yeah, I think the line that you're trying to draw, which I agree with, is between partisan party politics, team blue, team red, team orange, and that is not the job of the public service. But the public service is there to support and advise and implement the policies and programs of whoever has the confidence of the House of Commons at the time.
Thank you. I served on municipal council for 5 years, so I appreciate that comparison to how decisions are made, and it's very public. It's all done out in the open. There's very, very strict rules on when we can even go in camera, and there's specific topics that we have to deal with, very different than cabinet. Do you think most Canadians understand the whole concept of cabinet confidence? Because it's been portrayed very differently by the opposition as a way to keep secrets. I just wonder what you think about that, if Canadians actually understand the thinking behind what a cabinet confidence and why it's in place.
Oh, well, I would, I guess, as a matter generally, Canadians are busy with their lives and their families and their communities, and they don't think about how government works, except in episodes where there is some conflict or some problem. Then they may pay attention for a while, but then it fades away. So the issues that this committee's wrestled with around access to information and transparency are important. You could be drafting new transparency laws to shift the balance towards disclosure and so on. So that Parliament basically sets the overall balance points.
Thank you.
Okay, thank you, Ms. Damoff. Mr. Wernick, Monsieur Villemure pour 2 minutes et demie. Monsieur Villemure, 2 minutes et demie.
2.5 minutes, Mr. Villemure. Thank you very much, Mr. Chair. Mr. Wernick, I understand that the public service is impartial, and I agree. You stated that you read the Ethics Commissioner's report, and you know the conclusions. I would like to know what you think of the conclusions of the Ethics Commissioner's report. I believe that every person involved, the Prime Minister, myself as the clerk, the Privy Council, advisors, everyone tried to do their best and worked in good faith. I remember at the time, if the Ethics Commissioner had found that there was an infraction, the RCMP didn't say that there was one or that there wasn't. They just said that they couldn't do an investigation. And you can understand that that would plant the seed of doubt. I understand. But trust towards the government, how could we strengthen it? Because in cases like this where there seems to be a paradox, well, that creates doubt. Since then, Canadians have had the opportunity to choose during 2 federal elections. If, as parliamentarians, you are not comfortable with the transparency rules, you can change them. Thank you very much.
Merci, Monsieur Villemur.
Thank you, Monsieur Villemur.
2.5, go ahead.
Mr. Warnick, on a couple of occasions, you mentioned that it's 5 years ago, a long time. I think you'd stated that you're not a historian, but you are a professor and you are teaching governance. What lessons do you teach your students about this whole affair?
I don't talk about this affair as a specific. You can read my book on governance.
I'm just going to tell you from where I sit, that sounds supremely arrogant when I'm asking you a question in this committee. I'm not interested in buying your book, sir. I'm interested in you answering the question. What lessons were learned from this whole affair? And if your suggestion is that you don't delve into this conversation at all into your class, that's fine. But to continue to say, like, check my CV, check my LinkedIn, read my book, buy my book, it's not landing the way you think it probably is. So I'll ask you again, what lessons learned do you have from this affair, whether to students or to this committee for recommendations? Because ultimately we have a responsibility to have some kind of report or recommendations coming back from this. And 5 years later, it's still a mess. It's still murky, and it still undermines the people's faith in the democratic institution here. So
Parliament can change the laws. So 2 specific recommendations. One is that the law that was drafted and implemented by this Parliament in 2018 about deferred prosecution agreements has some ambiguity in it in terms of the evaluation of economic interest, which was the subject of one of the conversations. So you should go in and reopen the law and take a look at the language on what can and cannot be used in considerations around a deferred prosecution agreement, because it will come up again sometime in the future. So there's a job that only you parliamentarians can do. And if you're not happy with the rules about disclosure of cabinet confidences to police forces or judges, change the law.
Thank you. It really wasn't that hard. I appreciate that answer. That's all my questions.
Thank you, Mr. Green. Mr. Cooper for 5.
Thank you, Mr. Chair. Mr. Wernick, your telephone conversation with Jody Wilson-Raybould on December 19th, 2018 was made at the request of Justin Trudeau, correct?
I'm sorry? I didn't hear that.
Restate the question,
Your
please.
telephone conversation with Jody Wilson-Raybould on December 19th, 2018 was made at the request of Justin Trudeau, correct?
Not specifically to call her, but my recollection of it is, and you can read me back my testimony, is that he wanted to find out what her rationale was for not pursuing the DPA at the time.
And so Justin Trudeau testified that he did make that request in his testified to the Ethics Commissioner. And to put some context with respect to that call, hours before you initiated that call, you had met with the Prime Minister, his Chief of Staff, Katie Telford, and his then Principal Secretary, Gerald Butts, in which SNC Lavalin and the issue of deferred prosecution agreement came up.
Yes, that was our last meeting before the Christmas holidays and a 2.5 week break before we all came back in January.
Thank you for that, Mr. Wernick. I appreciate your answer. No. I appreciate you answered the question.
Point of order. Hang on. Mr. Cooper, please, I see your point of order. I'm going to maybe solve what you're going to be asking. I would just ask that you give Mr. Wernick an opportunity to answer the question, please, Mr. Cooper. With it, okay.
Thank you, Chair. I just thank you for that.
Go ahead.
So as I said at the committee, it was one of many issues that we discussed at a Christmas holiday wrap-up meeting.
Okay. Thank you for that. And to put further context with respect to that call, one day before that call, Jody Wilson-Raybould's Chief of Staff was summoned by Katie Telford and Gerald Butts and was told that by Butts and Telford that they didn't want to hear anything more about legalities. They wanted to get a deferred prosecution agreement done. So when the Prime Minister asked you to make this call, he was effectively giving Jody Wilson-Raybould her last chance to make the decision that he wanted before he fired her, wasn't he?
I'm not aware of the conversation that Ms. Telford and Mr. Butts had at the time. When I had my call, I wouldn't have been aware of that. And this was before Mr. Bryson resigned from cabinet and created the need for a cabinet shuffle.
Well, Mr. Wernick, that conversation of Ms. Telford and Mr. Butts is now well documented, backed up by contemporaneous notes taken by Ms. Wilson-Raybould's Chief of Staff. So let's look at the facts. After months of pressure on the Attorney General and the day following the meeting where the Prime Minister's Chief of Staff and Principal Secretary tell Ms. Wilson-Raybould's Chief of Staff, we don't care about legalities, just get it done, you give Ms. Wilson-Raybould a call at the request of the Prime Minister, wherein you state the Prime Minister is quite determined, that he's going to find a way to get it done one way or another, that he is in a very firm mood about this, and you were worried about a collision occurring between him and her. So those are some very strong words, veiled threats. Why would you use those words if, in fact, it wasn't Jody Wilson-Raybould's last chance to make the decision that the Prime Minister wanted before he was going to fire her?
You're hypothesizing an intention to fire her, which I was certainly not aware of at the time.
Well, you issued a number of threats after the Prime Minister's Chief of Staff had only a day prior, and his principal secretary said, we're done with the legalities. And then guess what? 2.5 weeks later, after this phone call, following the Christmas break, she was fired as Attorney General. So taken together, I would submit there is no reasonable conclusion that can be drawn other than that the Prime Minister fired Jody Wilson-Raybould when she wouldn't acquiesce to his demands to interfere in the criminal prosecution of SNC Lavalin. And you know what that's called, Mr. Wernick? It's called obstruction of justice, isn't it?
I think that's for the police to determine.
Mr. Wernick, you couldn't back up with any credibility the issue of SNC moving its headquarters. What about the jobs? What analysis had the government taken that at least 9,000 jobs were on the line?
So I think that was all covered at the Justice Committee and the production of documents for that. I don't have any of that material in front of me.
And the answer that you gave to Ms. May when she posed that question to you is that no analysis had been done.
There had been statements by the company and market disclosures, and there had been representations by the company, which are on the record.
This was a pressure campaign made by the Prime Minister, not in the public interest. It was clearly the Prime Minister acting in the interest of SNC Lavalin, and that's exactly what the Ethics Commissioner found.
Thank you, Mr. Cooper. Mr. Housefather for 5. Go ahead.
Thank you so much, Mr. Chair. It's always nice to watch Mr. Cooper as a prosecutor. He certainly fires off those questions well. But Mr. Wernick, I just want to come back to the issue. As far as I recollect, Jody Wilson-Raybould was shuffled from one cabinet position to another and then resigned. Is that not what happened in terms of your recollection of her history in cabinet?
Well, she was the Minister of Justice from during that period from December 18th until early January when there was a cabinet shuffle. The cabinet shuffle was created by Mr. Bryson leaving cabinet and led to a number of moves, of which she was one. She remained a member of cabinet, and she participated in the cabinet retreat in Sherbrooke that weekend, which is before the Globe and Mail story.
And then she was the one who proactively resigned as a cabinet minister, correct?
That would have been a couple of weeks later, I believe.
Yeah, no, I wasn't asking on timing. I just wanted to recollect that she was shuffled and then resigned. She was never fired, because the word fired keeps coming up for some reason, and just wanted to clarify that. Another thing I wanted to ask you, I remember in your testimony when you testified before the Justice Committee, you talked about the fact that, that there were not two classes of justice in Canada and the rule of law prevails. I was wondering if you still maintain that opinion.
In 2024?
Yes, as of today, do you still believe that?
I certainly hope so.
Fine. I note that only because, you know, we're here, and I think the purpose of the committee is to look into the RCMP's investigation. I personally trust in the RCMP. I believe they, you know, follow the rule of law, that they don't have political interference in their deliberations or in the way that they determine whether or not to prosecute or terminate work on a case. And I think that's the testimony that we've heard up till now on the RCMP side. And I just wanted to make sure that nothing in the RCMP's testimony here has changed your opinion about the rule of law prevailing in Canada. So I gather that's a no.
I think we have a no, and we have a very healthy set of feedback loops and accountability tools in Canada. I'll venture out and point you to the ArriveCAN issue, which has blown up in the last little while. So we have a parliamentary committee at work. We have at least 3, I think it's 4 officers of parliament at work, and we do have a police investigation. And in fact, there was an entanglement last week at one of the parliamentary committees because witnesses didn't want to compromise a police investigation. So we have all kinds of accountability tools in Canada which seem to still be functional.
Okay, well, that's good to know. I mean, checks and balances are always important. So let me end my questioning, Mr. Wernick, because I think really the purpose for you being here is still a little bit dubious to me, other than to rehash what happened in 2019. So can I just ask you, not whether you have any regrets, but do you have any thoughts to share as to improvements to the system based on your reflections over what happened with SNC that we should be considering as legislative or regulatory changes to put into effect, or procedural changes?
Well, as I said to Mr. Green, I think that there is some redrafting and clarification that could be put into the provisions around deferred prosecution agreements, because it will come up again. And I think, as I said at a previous appearance at this committee, I would like to see proactive transparency legislation. I'm very disappointed that Parliament dropped the ball on access to information, and you could write laws that require proactive disclosure of all kinds of sources of government information and make those practices permanent, because any future government can roll them back.
Question, Mr. Chair. So just one last question based on your experience, Mr. Wernick, and I do want to thank you for your service also, is if the RCMP wanted to get at materials that were cabinet confidence, and for whatever reason the clerk of the Privy Council rejected the request from the RCMP, does the RCMP not have other judicial tools it could theoretically use to obtain those materials or to seek to obtain those materials?
Yes, I mean, I'm not a lawyer. My understanding is you always have a referee, which is the federal court and the Supreme Court. And some issues on redaction and disclosure and withholding have gone to the federal court and even to the Supreme Court.
Tension between the executive, legislative, and judicial branches, and that would be a dispute resolution at the judicial branch. Thank you so much, Mr. Chair.
Okay, thank you, Mr. Housefather and Mr. Wernick. Mr. Brock for 5. Go ahead.
Thank you, Chair. I'd like at this time to move a motion that pursuant to Standing Order 108 Sub 1 Sub A, the committee order Mr. Wernick and the Privy Council Office to produce all records of communications between Mr. Wernick and any board members, employees, or representatives of SNC-Lavalin, now Atkins Realis, between the period of November the 4th, 2015 to March 19, 2024, and that these communications be provided within 14 days of the adoption of this motion. And I hope that we have unanimous consent.
Okay, thank you for that, Mr. Brock. Has that been distributed to the clerk or not?
It has not.
Okay. Just hang on a sec, please. Okay, so
Chair,
hang on, Ms. Damoff. My understanding is that there's no requirement for that to be sent to the clerk if it's a verbal notice. Mr. Brock has moved a motion. It is in order and related to this. Ms. Damoff, did you have something?
I just wondered, I did, Chair. I just wondered if we could suspend until we get a copy of it, please.
Okay, so it's been sent. I am going to suspend for like a minute. Is it in both official languages too? I'm just to be clear. Yeah. So it is, Ms. Damoff, it is a verbal motion, so there's no requirement for it to be distributed. What I'm going to do is I'm going to ask Mr. Brock to read it again slowly for the interpreters. If you can do that, Mr. Brock, go ahead, please.
Happy to. If I can find it now. That pursuant to Standing Order 108, Sub 1, Sub A, the committee order Mr. Wernick and the Privy Council Office to produce all records of communications between Mr. Wernick and any board members, employees, or representatives of SNC Lavalin, now Atkins Realis, between the period of November the 4th, 2015 to March 19, 2024, and that these communications be provided within 14 days of the adoption of this motion.
Okay, thank you for that, Mr. Brock. Mr. Wernick, I'm going to ask that you just hang on for a sec while this gets discussed. Ms. Damoff, I saw your hand. Is this in relation to the motion that's been moved by Mr. Brock?
It is, Chair. I still think we should get a copy of it before we start discussing it here.
Okay, so in discussions with the clerk, there's no obligation for a verbal motion that's presented at committee to be distributed, but we are going to try to distribute that as soon as we can. Do you have a copy of it, Madam Clerk? Just so that I'm clear. You should.
Not yet.
We don't have a copy of it yet.
Okay.
Okay, so it's going to be distributed. Mr. Brock has read the motion into the record. We're going to get that to you as soon as we can, Ms. Damoff. Any discussion on the motion?
Sorry, Chair, do you want me to raise my hand again? There.
Yeah, go ahead.
Mr. Wernick does not work for the Government of Canada any longer, and has not for 5 years. And I don't know how Mr. Brock can compel Mr. Wernick to provide anything to the committee when he's no longer working for the Government of Canada and has already said that he didn't take anything with him. So it just makes no sense to me whatsoever. He's a private citizen who has no, he doesn't work for the government.
Ms. Damoff, I'm going to, Mr. Brock was seeking unanimous consent for this motion. Do we have unanimous consent to adopt the motion as presented by Mr. Pour discuter, Monsieur Villemure? Okay, allez, s'il vous plaît.
On n'a pas la version en français.
We don't have a French version yet. The clerk is working on that at this time. That is why I asked Mr. Brock to read the motion slowly, so we can wait. Are there any other comments on the motion? Are we...
Go ahead.
Thank you, Chair. This is in relation to Ms. Damoff's most recent intervention. I get her point. I understand her point. I think the evidence we heard today was very clear, and that's why the motion references not only Mr. Wernick, but the Privy Council Office itself.
Thank you for that, Mr. Brock. In relation to the motion, and maybe this addresses Ms. Damoff's concern, if the motion would read, order Mr. Wernick and or the Privy Council, that might address the concern that Ms. Damoff has. I see your hand, Mr. Wernick. Are you waving goodbye, or are you trying to seek my
I'm
attention? Okay.
always trying to be helpful to the committee. I have no objection to producing what I have. I can tell the committee, if it's useful, that there was an inquiry by the Commissioner of Lobbying during the same period, started in March of 2019, that concluded in November 2019. And I very helpfully have some of the documents from the Commissioner of Lobbying. There was a production of documents to her at the time. So I'm quite happy to send that to the clerk of the committee this afternoon.
Okay, I appreciate that intervention, Mr. Wernick. Ms. Damoff, your hand is still up. Is it in relation to the motion?
It is, Chair. I'm just looking at the time and we have 3 minutes left in our meeting. I'm wondering if we could resume this on Thursday when everyone has the motion in front of them. Mr. Villemure does not have it in French. We really don't have time to discuss this properly, and we may want to make amendments to it, but we really need to see a copy of it. So I'm just wondering if we could resume this at our meeting on Thursday.
The challenge with that, Ms. Damoff, is that we've got the President of the Treasury Board coming on Thursday for an hour, and then we've got the former and current Ethics Commissioner coming. The notice hasn't been posted yet, but they are coming, and I've been asked by Mr. Villemure to find a little bit of time in that meeting to discuss an important issue in relation to the social media study. So I would like to dispose of this now. We do have a little extra time if we need it. I know the clerk is working on the motion, but is there any other discussion on the motion? If Mr. Wernick has indicated that he has no problem providing the committee with documents, and the Privy Council can provide documents to the committee as well as requested in the motion, then I'm going to seek what Mr. Brock had initially indicated, and that is to have unanimous consent on this motion. If we don't, that's fine. If we do, then that moves things along. Mr. Baines, go ahead, please.
I'm wondering if what Mr. Wernick is offering is, if it's sufficient enough for Mr. Brock to just withdraw.
We'll see once he offers that. But he's made the offer. Monsieur Villemure, oh, sorry, is that it, Mr. Baines, or?
Yeah, that's it.
Okay, thank you. Monsieur Villemure, s'il vous plaît.
Merci, Monsieur le Président. Dans la lignée de Monsieur Baines.
Thank you, Mr. Chair. And following up on Mr. Baines said, we could see what Mr. Wernick sends us, and depending on that, we could move forward with the recommendations.
For Mr. Villemure's intervention.
Okay, je m'excuse, Madame Damoff. Il n'y a pas d'interprétation.
Apologies, there was no interpretation. Is it working?
Ça marche pas? Ça marche, OK. Monsieur Villemure, si vous voulez
oui, je vais répéter
encore, s'il vous plaît.
Can you please repeat, please? After hearing what Mr. Baines said, I was wondering if we could perhaps receive the documents from Mr. Wernick, see what they are, and if Mr. Brock is not satisfied, then we could adopt the motion. This would allow us to decide on time. I would be interested in seeing what can be sent to us, and if that's enough, then great. And if not, we can move forward with the motion. The motion has been sent to all members in both official languages. So please look at your emails.
Proposing that Mr. Wernick has already made the commitment to provide the documents that he has. I know that you're also seeking documents from the Privy Council in your motion. Based on what Mr. Villemure just said, would you be satisfied in the committee receiving the documents from Mr. Wernick, assessing them, and then dealing with the motion later on, or do you want to deal with the motion right now? That's where we're at right now, based on what Mr. Villemure said.
Well, I appreciate the commentary from my colleague, Mr. Villemure, but the motion is very specific. It's information that still is in the possession of Mr. Wernick that may or may not be relevant to our study, and information that is still within the possession and control of the Privy Council office. We've heard evidence today, Mr. Chair, that prior to his departure, as the clerk of the Privy Council, he made sure that all of his records were retained. So he's not in a position to retrieve all of that documentation. Certainly, the current clerk and the staff at the PCO would be in a position to do so. So I'm not prepared to cede to Mr. Villemure's suggestion, because I think it just prolongs the delivery of information. I'd rather have everything that's in the control and possession of both entities, Mr. Warnick personally and the PCO, to be received by this committee.
Okay, fair point, Mr. Brock. Ms. Damoff, go ahead.
Thanks, Chair. I actually support what Mr. Villemure put forward as a suggestion, and I think as a committee we could ask Mr. Wernick to provide that documentation to us. I noticed now that we have a copy of the motion that Mr. Brock has asked for documents to March 19th, 2024. So my question is actually for Mr. Brock. Is he asking Mr. Wernick to provide private correspondence that he might have had since he left government? That seems completely unreasonable, Chair.
I am going to seek clarity from Mr. Brock on, I see Mr. Wernick.
It's totally, I've had no communications with any of those companies since leaving government, so it will be a null, it'll be an empty file.
So, Mr. Brock, so the challenge that we have right now is that we do have a motion that's been presented. We have to deal with the motion as presented on the floor. And Mr. Brock, and I appreciate the intervention of Mr. Villemure, and I appreciate your intervention. Mr. Brock has proposed a motion. He did ask initially for unanimous consent on his motion, so I'm going to seek that. I'm going to seek unanimous consent. Do we have unanimous consent on that? Okay, Mr. Villemure, we. Mr. Green, and I just need unanimous.
I don't think we agree, because we wanted, as Ms. Damoff mentioned, to potentially offer some amendments.
Okay, so there's no agreement for unanimous consent.
Okay, yeah, sorry,
Mr.
Mr. Chair,
Housefather, I'm going to accept that. So on the motion, not seeing any further discussion, I am going to call for a vote. So, Madam Clerk, if you want to take the vote, please.
Point of order, Mr. Chair. I'm so sorry.
Chair, my hand was up.
It wasn't, Ms. Damoff, because I did look at the screen. I'm sorry, but it was not. So I called the vote. I'm going to go to the vote right now. Thank you. Sorry. Go ahead, Madam Clerk.
Order. Point of order. There was no vote called. Point of order. There's no vote called, Mr. Chair. Ms. Damoff had her hand up. Ms. Damoff had her hand up. Mr. Chair, you were not paying attention. You're looking at your colleagues, looking for direction. So, I'm not yelling. You're yelling. You should turn your mic off, because I have a point of order. Mr. Barrett, I have a point of order. I have a point of order.
So let me just hang on a second. Mr. Chahal, I appreciate your point. As I was discussing the options, and I saw that there was no consent from Mr. Housefather had indicated that, I checked to see if there were any further hands up or any further discussion, and there was not. And so I did call the vote, and I am going to ask the. I do see a couple of hands on a point of order. Ms. Damoff's hand is up now, and then Mr. Green. George, you're not the chair of this committee, okay? So let me do my job. If you have a point to make it and make it relevant, okay?
You have not allowed me to talk about my point of order, Mr. Chair. You've interrupted me every time.
You did say.
I have a point of order, and you've interrupted me again,
George,
as did your colleagues.
Your point of order was that the vote wasn't called, and I just answered that and said that the vote was called. So I'm going to go to Ms. Damoff and then Mr. Green after that, because I did see your hand. And this is on a point of order. So go ahead, Ms. Damoff, please.
Thank you, Chair. And just on the point of order, I did have my hand up if there was a second difference between when my finger hit it and when you called the vote. But we were talking about Mr. Villemure's suggestion, and I had my hand up to offer an amendment to the motion. I really think that we're not that far here. Mr. Wernick has been very open about what he can provide to the committee. And Mr. Brock wants to know what correspondence he's had. He can provide us with what was tabled before. He said he has nothing for the last 5 years.
Thank you, Ms.
to
Damoff.
vote on this so I think, Chair, in fairness, you should allow us to amend this motion and allow Mr. Wernick to provide the committee with the information that he has. I think you're trying to jam the vote, Mr. Chair, and I don't think that's
Actually, I'm not.
appropriate.
And yeah.
Well,
No, because I didn't see any.
I know, but it's difficult
like,
when you're virtual too. And in fairness to you, Chair, I recognize that it's hard to try and manage the room and virtual as well. But I feel like I'm being put at a disadvantage here because I'm virtual because I'm sick this week. So.
Thank you. Mr. Green, on your point of order, please go ahead.
Mr. Chair, I do caution you on this as somebody else who's like, so, you know, my intention is to support the demand. My intention was to support the demand for documents. I do believe that there ought to be procedural fairness when debating motions. I do not believe, sir, that you have provided procedural fairness for debate. I might not agree with tactics around filibustering or running out the clock, but what I am cautioning you against is creating a very dangerous precedent in this committee of having a what could be viewed as a hyper-partisan chair, sir. I would say rolling from a unanimous consent directly into calling a vote offers no time for adequate debate, and I think would cloud your ability to chair this committee on a move forward basis. And I say that respectfully as somebody who believes that you've done a good job to date, but I am concerned with the way that you are handling this particular motion, even in supporting the motion. So I would ask for your indulgence to allow debate when motions are called, because the precedent you set by not allowing debate when it's called and kind of surreptitiously calling votes, it shows a level of partisanship that I haven't seen in you to date, sir. So I would appeal to your reconsideration of that and allow a debate to happen and allow that process as is the standing kind of procedures and courtesies within the way in which we conduct this committee.
So I do appreciate that that intervention, and I'm going to. So just for clarity, there were no hands up when I called that vote. Okay, so I just want to make that very clear. Now, Ms. Damoff, if your hand went up a split second later, and I didn't see it when I went from the unanimous consent to calling the vote, that is what happened. Okay, so I'm gonna go back on some good faith. I know you had an amendment, Ms. Damoff. I'm going to give you an opportunity to present that amendment, and then my hope is that we can go to a vote at that point and dispose of this motion, because I'm sensing that most of the committee is in agreement with what Mr. Brock has proposed. So I'm going to go back and I'm going to allow you, Ms. Damoff, to put your amendment forward, and then we can deal with it. So go ahead, please.
So thank you, Chair. And just in the spirit of what Mr. Villemure had suggested, I would just suggest removing the words "and the Privy Council office." That would allow Mr. Wernick to provide the documents that he has, as well as the non-existent documents between 2019 and 2024. And once we've received those and reviewed them, if we feel that we need more information, we can deal with another motion at that time.
Okay, so
I think what I'm suggesting respects what Mr. Villemure had suggested that we do. And since we want to vote on this apparently today, I think that change, and if Mr. Brock feels once we get that information, or that I should say that the committee feels that that information is not sufficient, we can ask for more at that time.
Okay, thank you. So Ms. Damoff has proposed an amendment to remove "and the Privy Council office." So any discussion on that amendment? Do we have consent to? We don't have consent. Okay. So why don't we go to I don't see any further discussion, and I don't see any further discussion. So I'm going to go to the vote on the amendment. Go ahead, Madam Clerk.
The vote is on the amendment from Ms. Damoff to delete the words "and PCO." Mr. Baines?
Yes.
Ms. Damoff?
Yes.
Mr. Hausfader,
Yes.
Mr. Sorbara,
Yes.
Mr. Shahal,
Yes.
Mr. Barrett,
Why would they want to get rid of the PCO documents? Yeah, I'd vote no.
Mr. Brock,
No.
Mr. Cooper,
No to the Liberal cover-up.
Monsieur Villemur, Mr. Green. That's a no?
No.
Yeas 6, nays 4, oui 6, non 4.
Okay, so the amendment carries. We're going to go to the main motion as amended. Mr. Barrett, go ahead.
This is fascinating that we have Liberal members who are working overtime to try and bury documents from PCO. So we have Mr. Wernick, who says he can just email them over this afternoon, what he's got. So that satisfies that. The documents that he says don't exist, obviously he doesn't send those. But the documents from PCO, I heard Mr. Baines say they don't exist. Well, then that's a very quick return for PCO to make. So if there's nothing to see here, I really don't understand why that they are so determined to keep the information from coming out. You'll recall that we were told that sunshine is the best disinfectant, and that's what we would see from Justin Trudeau. But what we're seeing from his parliamentary
Point of order, Chair. Are
secretaries.
we debating the motion in front of us or my amendment? Because my amendment's already passed.
We're debating the main motion as amended.
Okay,
Go
so
ahead.
the main motion doesn't even mention PCO anymore. So I don't understand. Mr. Barrett is accusing me of trying to cover something up. We voted on the PCO part. That's done.
Mr.
Now we're
Barrett is on the main
motion.
motion. He's discussing the main
Right?
motion. He has the floor, Ms. Damoff. Go ahead, Mr. Barrett.
We have Ms. Damoff, a parliamentary secretary for Justin Trudeau, who literally doesn't even want me to say PCO. She's trying to say that it's out of order for me to talk about PCO documents that were in the motion. And we have the former clerk of the Privy Council in front of us dealing with Justin Trudeau's SNC Lavalin scandal, where he used his powers to protect himself from effective RCMP investigation. And now we have multiple parliamentary secretaries and members and Liberal chairs who are trying to, again, cover up what happened. And it's absolutely egregious, but of course it's also transparent to see that that's what we're doing. Voting for a motion that is completely neutered, it's not providing the transparency that Canadians deserve, is an affront to the basic premise of openness, even by how far it's fallen under this government. We seem to plumb new depths with their interest in trying to cover up for a corrupt prime minister every day.
Okay, thank you, Mr. Barrett. Ms. Damoff, your hand is still up? Or is it?
Yes, Chair, it is. Thank you. Mr. Barrett insists on using words like cover up and corrupt. And he knows that I'm going to get my inbox full. Already social media is talking about me being a pearl clutcher because I don't like getting the kinds of messages that I get. I think maybe I should just walk over to Mr. Barrett's office and show him the kind of wording and emails that I get and the things that I'm called. We are not a corrupt government, Mr. Barrett, in spite of what you want to say. The fact is that Mr. Villemur put forward a reasonable suggestion, especially since we're dealing with this at the last minute in committee. The change was, I was quite clear that if the documents that we receive are not adequate, we can ask for more documents later. This has been thrown at the committee at the last minute. There is absolutely no cover up, and to imply that there is, or to imply that there's some kind of corruption happening in the government of Canada is just ridiculous, and it feeds in to all of that kind of mistrust of our democracy that for some reason the Conservatives want to put out there with Canadians. So, Chair, I feel really strongly. I was quite clear that this was being removed in order for us to get documents quickly. If this whole thing is about why the RCMP is not investigating. We've gone down such a slippery slope into other things. It's just mind-boggling to me. But you know, we need to stop accusing people of covering up and being corrupt when that's simply not the case.
Okay, thank you, Ms. Damoff. We don't have endless time here. Mr. Cooper?
Thank you, Mr. Chair.
On the motion. On the motion.
On the motion. I know that it's really, really difficult, it must be, to have to come in every day and defend Justin Trudeau's corruption, but that's what these Liberal MPs have to do. And it's really, I hope the voters in my riding take note. Look, this motion has been completely neutered, it's been gutted, and there's only one explanation for it, and that's to continue a cover-up that has gone on for 5 years. That's right. Vote against the motion.
Thank you, Mr. Cooper. Ms. Damoff, your hand is up. I suspect that it was for your previous intervention, or is it for a new one?
No, Mr. Chair. I mean, again, maybe I'll have to walk over to Mr. Cooper's office. I don't think that anyone in this committee room right now wants to try and destabilize what our country is like. But these consistent claims of cover-up and corruption. Mr. Chair, I think I was pretty clear when I moved my amendment that this was to provide documents quickly and then we can revisit. That is not a cover-up, and I wish my colleagues would retract their comments. And I think we're probably ready to go to a vote, Chair.
Okay. We are, go ahead, Mr. Barrett, quickly, please.
Ms. Damoff says that there's a trigger at some point that would have her order the production of other documents. So if there's an amendment to that effect, I mean, that would be supportable and would demonstrate transparency and all of the nice things that we're being told we're to believe. But it's important that the context is very clear for the record. This is a case where Justin Trudeau was found to have illegally used his position to interfere with the Attorney General's role. So this isn't above board behavior, and we know that he's used his office to shield the release of documents that are politically damaging. That is the definition of a cover-up. It was true in this case. It's true in the case of the Winnipeg Labs, where they said it was a case of national security, but it's not national security. We had judges and members of Parliament identify that, in fact, it was politically damaging and not damaging or injurious to the security of our country. And this is a pattern that we see from the government. And if they don't want to be labeled as corrupt or having participated in cover-ups, well, then there's a remedy, and that remedy would be transparency. And so we'd welcome an amendment that would have a trigger to have documents ordered from PCO. But in the absence of that, it can only be described as what it is, and that's the government being true to its form, and that's protecting itself politically at all costs, and that's done by a cover-up.
Thank you, Mr. Barrett. On the main motion as amended, Mr. Villemure.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I would like to propose an amendment. Following the motion as amended, we would add, if the documents received by the committee 10 years after the request do not satisfy the committee, that the Privy Council Office submit all the documents requested within 10 additional days. I believe that this amendment would be a middle ground because Ms. Damoff is not saying that she does not want this, and Mr. Barrett had a good point. We don't want this to be a cover-up. So having a trigger here is something that I would propose. So 10 days after we receive the documents, and if we are not satisfied with the documents, well, automatically we would request that the documents from PCO be sent in 10 days. We are currently writing this up. Thank you for the amendment, Mr. Villemure. I see Ms. Damoff.
Ms. Damoff.
Sorry. Thanks, Chair. Thanks, Mr. Villemure. I think we should probably go with 14 days because Mr. Wernick said that he could get it to us today. So in that case, we're shortening the timeline. I don't know if PCO can even provide 5-year-old, 9-year-old documents that quickly. So we may have to be flexible on our timeline, but I wonder if Mr. Villemure would consider the 14 days, just given that Mr. Wernick has already said he can provide it with us today. But other than that, I think it's a reasonable amendment, and I appreciate the professional way that he conducts himself in this committee.
Okay, thank you, Ms. Damoff, and yeah, I see that. Just, I'm going to just excuse myself because it's a sub-amendment that we're dealing with, not an amendment. So I just want to clarify that. The other thing, it's...
We're amending the motion as amended.
Right, so, but okay, I realize you're amending the motion as amended, which, okay, and that, according to the clerk, is a sub-amendment. So, just to be clear, but I think we all know what we're dealing with here. So, Mr. Wernick, so the only thing I need clarification on is that, we'd like timelines 14 days after we receive the documents from Mr. Wernick, if we're going to deal with that. Mr. Villemure, I'm going to need, vous êtes en accord avec l'échange de 14 jours? Okay, merci. Mr. Wernick, I see your hand. Go ahead, please.
I'm trying to be helpful to the committee, Mr. Chair.
Appreciate that.
You may be debating a difference or a distinction without a difference. I don't have private records. I retain some PCO records relative to my function as clerk. They are the records that were provided to the Commissioner of Lobbying or to the Ethics Commissioner. So there won't be, these will be PCO records, and I just need a trip to Staples, and I will get them to the clerk of the committee. But they're basically the same thing. They are the PCO records that were provided to the Commissioner of Lobbying and to the Ethics Commissioner.
Okay, thank you.
I would suggest the clerk will want to review some of these because some of them involve confidences and are marked with solicitor client or commercially sensitive or secret or whatnot. So she will have to wade through those issues on behalf of the committee.
Yeah, and just to clarify, by clerk, I think you mean the law clerk, right, Mr. Wernick?
That's up to you.
Okay, so we have an amendment from Mr. Villemure. The amendment is, go ahead, on the amendment.
Did Ms. Damoff move a sub-amendment for the date?
Well, no. So Mr. Villemure, Ms. Damoff's suggestion was 14 days, right? So we're working on the basis that it's 14 days after the receipt of Mr. Wernick's information, okay? So we likely will need a sub-amendment then from Ms. Damoff to do that. So I'm going to encourage her to do that, just to sub-amend Mr. Villemure's motion of 10 to 14. Ms. Damoff?
Yeah, that's fine. I think he accepted it. So do we need to vote on that?
We need to move a sub-amendment. So you can't just accept an amendment like that. So, okay. So just so that we're clear, we're on the sub-amendment proposed by Ms. Damoff to change 10 to 14 days, and I'm including after the receipt of Mr. Wernick's documents, okay? Are we in agreement with that? Okay, yes we are. Are we? Okay. So the sub-amendment as proposed by Ms. Damoff and Mr. Villemure, Mr. Villemure's amendment as amended, are we in agreement with that? And that is 14 days after we receive Mr. Wernick's documents. Are we in agreement with that?
The 14 days.
14 days.
That's the Ms. Damoff's suggestion.
Correct.
Or amendment. Yes, we
Okay.
agree.
We agree with that. Okay. So now we're on the main motion as amended several times, which includes Mr. Wernick's documents and documents from the Privy Council office 14 days after we receive Mr. Wernick's documents. So on the, okay, hang on a sec. So what we're voting on to be clear, if the documents received are not satisfactory, that the PCO provide the documents within 14 days. Just hang on a sec
Do you
here.
want me to repeat?
Yes, if you don't mind, Madam Clerk, just repeat that. I can't read your writing. Okay, hang on here. Okay, I'm going to need everybody's attention here because this is what we're dealing with right now. Okay, go ahead, Madam Clerk.
So the amendment that was moved by Mr. Vilmer, I will repeat because it was not in written text, okay? So basically is after, on the motion as amended first, it says after the adoption of this motion, it would be semicolon, then we would add if the documents received by Mr. Wernick, if the committee judged that it is not satisfactory, within 14 days of the reception of the documents from Mr. Wernick, that PCO provide the documents within 14 days.
Thank you, Madam Clerk.
This is what we're voting on.
So this is what we're voting on right now, and I think that captures the spirit of what you were discussing, Ms. Damoff. I see your hand.
I just need some clarity, Chair, on how it's changed. Is it's the committee is going to decide if the documents are satisfactory or not. I just want to make sure that that's in there.
Correct.
And then it's 14 days from when when the committee decides it's not satisfactory. Is that right? Or I guess my first point is I think it needs to, who's deciding that the documents are not satisfactory, and I think that should be the entire committee. And then what is the time frame for the 14 days and when does that kick in? It's just clarity I'm seeking, Chair.
So just need everybody's attention, please, just so that we're clear on this, that the expectation is that it will be the decision of the committee on these documents that are received by Mr. Wernick, okay, if in fact we need the PCO. So if we need to include that in the motion so that it's clear, but my understanding and the clerk's understanding, based on the discussion that's happened today, is that that's the way it is. It will be a decision of the committee as to whether to get the PCO documents within the 14 days. Now, that 14 days is after the receipt of the documents that Mr. Wernick is going to provide to the committee. Okay, so Mr. Barrett, on this, does that, first of all, does that clarify things, Ms. Damo? Thank you. Go ahead, Mr. Barrett.
So the challenge, of course, is that that supposes that there's an interest in moving forward with the rest of the documents. What I would prefer to see is if we're not putting the PCO documents being ordered today, that it's time triggered. So I appreciate there needs to be some subjective analysis of that, but if it comes back to the full committee, we've been like mired in this for quite some time already. Mm-hmm. I would forecast that the same would happen again, and so I would rather put it to the chair that the documents have been well received or not, and then if not, then the production is issued. But if it comes back to the committee, that might just be the end of it then.
So, might I suggest that if, and I'm just throwing this out there, if one party is not satisfied, then that could trigger the discussion at the committee, which I can facilitate at a committee meeting under committee business. I'm just trying to figure out some sort of mechanism that we can use, and to me, that would be the mechanism. If somebody indicates to me that they're not satisfied with the documents that Mr. Wernick provides, then that would force a discussion at committee, at which point we would make a decision on the PCO after a committee discussion. Go ahead, Ms. Damoff.
I think that's reasonable, Chair. If someone on the committee is not satisfied with the documents, then you can call a committee meeting. I think that's a very reasonable suggestion and
yeah.
approach.
And my reason for that is to address what Mr. Barrett's concern is, Ms. Damoff, and that is that this is not prolonging itself. You know, we're trying to figure out whether we're happy or not with the documents. So.
Yeah, I think we're all on the same page here, Chair. I really do, and I appreciate your suggestion.
Okay. So I do have to go back to Mr. Barrett. Does that satisfy if we have, we can even put it in the motion that if one party is not happy with the documents that come back, that would trigger a discussion at committee, and the chair would signal when that would happen.
Mr. Chahal suggested that a committee of the two Michaels here that we'd be able to decide, but barring that, I think that we have an understanding that it'll come back to
Okay,
us.
so I'm not going to put that in the motion. I'm not going to ask for anybody. I think we can have a clear understanding of what was discussed. Madam Clerk, are you clear on that? Okay, thank you. So we are on the main motion as
the amendment from Vilmer as amended.
yeah, so the amendment from Mr. Villemure as amended. Just bear with me a sec. Okay. Okay. So is there consensus and agreement on the amendment proposed by Mr. Villemure on the amendment? Okay. I'm not seeing any hands on the screen, so I'm going to accept that. And now we are on the main motion as amended. I don't see any further, tell me that's not a discussion. No, it's a thumbs up, okay. All right, I don't see any discussion. Do we have consensus on the main motion as amended and not require a recorded vote? Okay, we do. Mr. Green, thank you. Okay, so the motion is adopted. Mr. Wernick, I want to thank you for your time today, and thank you for your patience in sticking around and providing us with the information that you did. I want to thank the committee clerk, the analysts, and the technicians, and everyone on behalf of Canadians. Thank you. The meeting is adjourned.